Let's issue Spot another fact pattern. And this one, as you can tell from the title, is in torts. If you had been on a bar exam, you wouldn't know the subject. So you look at the calls of the question first to try to rapidly figure that out if you can, because that narrows down the field of law. So here I see what claims, if any, may Melinda assert against Wilbur, and what damages, if any, may she recover. Claims. Well, an individual against an individual. Melinda v. Wilbur. So it's probably torts, property, or contract. But I can't tell yet which of those three it is. Second call, again, claims, but now this is Jack v. Lawyer. Notice this is not a professional responsibility call. If it were, it would ask if lawyer has violated any rules or breached a duty. But this is claims. This is a civil suit. So likely this is malpractice, which means negligence and an underlying claim that lawyer represented Jack for. All right, the hypothetical. Jack owned the world's largest uncut diamond, the star, worth 1 million uncut, but 3 million if cut into finished gems. Of the 20 master diamond cutters in the world, 19 declined to undertake the task because of the degree of difficulty. One mistake would shatter the star into worthless fragments. What are they giving me all that for? Probably because of a damages claim, and damages must be certain. It's uncertain that that diamond would ever be worth 3 million. Okay, one master diamond cutter, Chip, studied the star and agreed with Jack in writing to cut the star for $100,000, payable upon successful completion. As Chip was crossing the street to enter Jack's premises to cut the star, Chip was knocked down by a slow-moving car driven by Wilbur. Wilbur is the defendant in Call 1. Wilbur had driven through a red light and did not see Chip, who was crossing with the light. Chip suffered a gash on his leg, which bled profusely. So here we have negligence, but I'm confused because the call is about Melinda v. Wilbur. Though an ordinary person would have recovered easily, Chip was a hemophiliac, an uncontrollable bleeder, and died as a result of the injury. Chip left a widow, Melinda. Aha, so Chip's widow wants to raise claims against Wilbur. Now, torts on bar exams is generally common law or majority law. Under the old common law, a tort claim died when you died. So rights were personal. You had to raise that right yourself. But most jurisdictions, a majority, have survivor statutes. So Melinda can stand in Chip's shoes and assert a claim of negligence against Wilbur. So you would have the usual issues in a negligence action. You would need to establish that there was a duty. Wilbur was driving a vehicle. He was moving slowly. What would his duty have been? A reasonably prudent driver would stop at a red light, would pay attention and stop at a red light. Then breach of the reasonably prudent person would be that Wilbur breached his duty when he ran through the red light and didn't see Chip. But this is a red light, so we have a vehicle code here. We have an issue of negligence per se. There are vehicle codes that say you must stop at a red light. So another issue besides the general duty in negligence would be negligence per se. Can we establish that Chip was in the class of persons meant to be protected by the vehicle codes, and that the injury he suffered was the kind of injury you would suffer. What about the fact that he was a hemophiliac? That raises the eggshell plaintiff rule. We take the plaintiff as we find him. So that paragraph goes to call 1, to negligence. And Melinda can sue Wilbur for wrongful death, sue for negligence. And so you would do a full-blown negligence analysis on call 1. What about the next paragraph? Jack, who still has the uncut star, engaged lawyer to sue Wilbur in negligence for the $2 million difference between the value of the diamond as cut and as uncut. Lawyer allowed the applicable statute of limitations to expire without filing suit. Okay, this is kind of a classic malpractice call. Jack would be suing lawyer for legal malpractice, which means negligence in the representation. So we have to find a specific duty that lawyer breached. A reasonably prudent lawyer would file within the statute of limitations. Jack did not, so he breached that duty. What's the problem with a malpractice suit? Well, it's a case within a case. In order to show that Jack has damages that he can collect from lawyer, he has to show that he would have recovered more, or that the outcome would have been different had lawyer not breached his duty. In other words, had lawyer filed within the applicable statute of limitations. So to analyze that, you have to look at the underlying negligence claim, and there we have a problem. We can analyze all the elements of negligence for the malpractice claim all the way through proximate cause. It's foreseeable that if an attorney fails to file in time, his client is going to lose his opportunity to bring suit for his losses. Look to the underlying claim. The underlying claim here would be Jack v. Wilbur for negligence. But there are lots of problems with that. Is Jack a foreseeable plaintiff? Is it foreseeable that somebody would have a very valuable contract with the person that Wilbur just hit? And even if you can get past that foreseeable plaintiff, that duty to Jack issue in negligence, look at damages. Damages must be certain and not speculative. And the court isn't going to award damages in tort for purely economic injury. Did Jack suffer any kind of an injury other than an economic one? I don't see it. Not only that, but the damages aren't certain here, are they? Because Jack is suing for the $2 million difference between the uncut diamond's worth and the cut diamond's worth. But one mistake would have shattered that into worthless fragments, so it wouldn't even be worth the $1 million that it was worth uncut. Those damages are very speculative. It's not at all certain that Chip would have been able to cut that diamond accurately and make it worth $3 million. So those are the underlying problems in Jack's claims. The fact that he is probably not a foreseeable plaintiff whom Wilbur owed any duty as a driver driving down the street, because Jack was not in the zone of danger. He was simply someone who had a contract with the person Wilbur hit. So the duty problem, the foreseeable plaintiff problem, and then the damages problem. All right, two large calls, a full-blown negligence call in call 1, and then a full-blown complex negligence call in call 2. So how do you deal with that in limited time? This was a 1-hour essay. It would take me 15 minutes of that hour to issue Spot this hypothetical as I've done here, and then organize the issues, at least mentally, if not jotting them down on the bottom of the page. So I have maybe 45 minutes to write this. Am I going to give equal time to the two calls? Probably not. I'm going to give a bit more time to call 1 and really convince the grader that I understand negligence. I understand all the issues involved, foreseeable plaintiff, the duty, on 2 levels, reasonably prudent person, and also negligence per se. I'm going to work my way all the way through negligence in call 1, convincing the reader that I know how to do this, to create a great first impression on the reader. In call 2, I'm not going to so carefully define the elements. I'm going to focus on the fact that this is a case within a case. And I'm going to do it as rapidly as I can. And in the analysis of the underlying case, not the Jack v. Lawyer, but the underlying case that Jack would have had, Jack v. Wilbur in negligence, I'm going to focus on the duty element, the foreseeable plaintiff element, because that's a problem for Jack, and the damages element, because they gave me all those facts that show me that the damages here would be very speculative. They would not be certain at all. So I can do call 2 in slightly less time than call 1. Hopefully you are going through these debriefs, these issue spotting exercises, with an outline in front of you so that you can look at the way your outline is organized and whether it's effective and whether you have rules that it's going to be easy for you to remember. Notice that you don't want to have a 600-page book in front of you to madly look things up in. You want a nice, concise outline, the kind of final outline that you would be memorizing for your exam, whether it's a law school exam or a bar exam. I hope this kind of walkthrough of the hypotheticals is helpful to you to see the kinds of facts that are raised in these exam hypotheticals that let you show a grader what you know. And I say that very deliberately, which is the way to think about it, that it's an opportunity to show a grader all that you've learned, all that you know, all that you understand. If you can take that mental attitude, these will move a lot better for you.